So we're going to talk about domestic violence, and first of all we're going to talk about what is domestic violence. So domestic violence is defined very broadly. It includes physical abuse, hitting, pushing, all the obvious types of behaviour, sexual abuse, emotional, psychological abuse, financial abuse, and controlling behaviours. So it's an extremely wide definition, and it tries to capture a lot of different types of behaviours. If you have concerns about your property, another family member, or even an animal, that can be captured under the broad definition of family violence. These sorts of behaviours also apply to children. So if a child hears or sees or witnesses any family violence, they're also able to be protected from those behaviours. Family violence intervention orders are applications that you can make for protection to protect you from violence from family members. And once again, this definition is very, very broad. It includes people you have an intimate personal relationship with, parents, children, relatives by birth or marriage, or people that you treat as family members. So guardians, carers, other people that are closely involved in your life. So the issue really is whether or not you feel unsafe in any situation, because these rules and laws that have been put in place are there to ensure that your safety is protected. Excuse me, there's just something happening in the background, and my glitch in getting online has ruffled me, for want of a better word. Anyway, we will get there. Now, what do you do if you feel unsafe in any situation? Your safety is always paramount. If it's an incredibly unsafe situation, especially if there's physical violence, you call the police. You call the police by ringing 000, and they must attend immediately. When they come to the home, and it's generally in the home that they're called, they'll assess the risk, and they've got a number of things that they can immediately do to make you feel safe. If a crime has been committed, hitting is a criminal offence, and the police can arrest and issue a warrant against that person. They can either bail them or they can lock them up. And they're in the most severe cases. In other situations where the risk is perhaps not so high, they can issue a safety notice, which has the immediate effect of removing the person from the home. They may not issue a safety notice. They may just tell one of the parties, generally the perpetrator, that they need to leave the home immediately. They can, if you tell them that there are guns in the house, they can search that house and remove the guns. If a safety notice is issued, they have to take the matter to court within 24 hours. Otherwise, the police, after they're satisfied that you're safe in the home, may apply for an intervention order in a minute. If you're not in an emergency situation, you can, but you feel unsafe generally, you can attend the police station and discuss what the safety issues are that you're experiencing. They will carry out a risk assessment. They can go back to the home and get the guns if there are any guns. and they can apply for an intervention order for you and your children if the risk has been considered high enough for them to become involved. If they don't consider that they need to assist you in the process, they will refer you to the court generally and ask you to apply for an intervention order, which you're able to do on your own behalf. Now, if you do have to go to the police station, they will link you in with a number of support services. They may refer you to an emergency housing organisation, and they will assist you through the whole process. Where the police do make an application for an intervention order on your behalf, they become the applicants, and you and the children that need to be covered will be the affected family members. So once you've worked out your pathway, whether it's with the police intervention very early on or at a later stage, or you then having to make the application yourself, your next step will be attending court to either fill out the application forms yourself. During COVID, all of the forms are online at the Magistrates Court website, and they can be filled out online. If you are a self-represented litigant, I suggest that you perhaps telephone the Magistrates Court. All the different courts around Melbourne and in the country have different ways of operating and different guidelines. So it's probably a good idea to ring the court and let them talk to you about the best way of negotiating through the process. If you are able to go to the court personally, they will give you the forms to fill out, and the clerk of courts will generally go over those forms with you, and they will carry out their own risk assessment. In most cases, the matter will immediately go before a magistrate, especially if you need interim protection. So once your application has been made for an intervention order, and if you need immediate protection, the next thing that happens is that you will go in seek an interim order before the magistrate. So this is done without the other party being present. And so generally it's not such a stressful experience because you're there on your own. You will be required to give evidence in the witness box, which can be a little stressful, but at least it's only you and the magistrate, and the other party is not in court. So when the magistrate is hearing they will generally read what you've written and ask you whether everything that you have written is true and correct. And depending on what sort of protection you need and what sort of orders you're seeking, they may ask you questions about the evidence you're giving, and they may want to know a little bit more information. Because there's a number of orders that can be made, and they should be made in response to the risk and what is required to keep you safe. So the sorts of orders you can seek are that the most obvious and general order that is always made is that the other person does not commit family violence and or damage property. But there are also orders that can be made which will have the effect of excluding the other party from the family home and not allowing them to come generally within 25 or 50 metres of the home, which means they can't drive by the house and stalk you, and they can't hang around the environs. They can't publish things on the internet about you. They cannot contact or communicate you or use a third person to contact or communicate you. And when you're filling out your application for the intervention order, you can actually tick the boxes which indicate which orders that you want. And so when you're giving that evidence and having conversations with the magistrate, that evidence is sworn evidence and that is recorded. So you need to be aware that the other party can seek a copy of that recording. You need, and that recording can be used in the further hearing of this case. So you just need to be very aware that whatever you say is evidence that you can be cross-examined on later if the case reaches a final hearing or there are family court proceedings. Now, whether or not children are going to be included on the order is at the magistrate's discretion. And if the children have heard or witnessed violence, generally the magistrate will err on the side of caution and include the children, but it just depends on all the circumstances of the case. When you go to court, it's very important that you orders with you, because when the interim order is being made, the magistrate has the power to suspend family court orders. If that happens, there's an expectation that you will go to the family court and have them look at the current parenting orders because that suspension does not last forever. It used to be for 21 days. However, they've extended that time. There are now no time limits, but they will not suspend them forever. So if you go back to court for your intervention order at a later date, they may cease that suspension. They want you to actually do something about these orders in the family court. And that's because when you're applying for an intervention order and children are being included on that order, the court their primary purpose is to make sure the children are safe. It's not about making orders that are in the best interest of the children, which is what the family court have to do. And when you're making orders in the best interest of the children, there's a myriad of situations and circumstances that have to be looked at. It's a far more complex situation. Whereas in the magistrate's court, they're trying to put some barriers around everyone just to keep them safe. And what they're actually trying to do is far more limited, even effective, but it's not such a comprehensive exercise. Generally, the interim order will be made until your next court event. An interim hearing is the beginning of your story, and there will be a number of court events after the interim hearing if the defendant or the respondent wishes to challenge the case. In some situations, you won't be granted an interim hearing. That doesn't mean your case is ended. You can proceed just without your application, but you will have no immediate protection. The other thing to know is that if an interim order is made, it's not effective on the other party until it is served on them. So you will get a copy of the order after you leave the court, and the police should liaise with you and let you know when it has been served, and at that time it is effective. So there is a possible hiatus period of time where you may not want to go home, or you might want to put other things in place until you know the other party has been served. So when you're given your interim order, if one is made in your favour, you will be told about the next court date. And the next court date is usually set down a couple of weeks later. However, with COVID and depending where you live, the system now is in a state of arise, so you may not get a court date actually until next year. But the next court hearing, which is a mention and takes place after the respondent has been served, is an opportunity for the parties to try and resolve the matter, or adjourn it so that there can be further hearings, which I'm going to talk about in a minute. Now, there are a number of ways these matters can resolve without having to go to a final hearing. And what's appropriate for you will depend on the safety issues that you need to address. So in some situations, the other party doesn't come to court, and the court will then generally make a final order in your favour. That's the easiest scenario that you can actually face. You may, however, be in a situation where the other party has written to court and told the court that, you know, they're having an operation and they'll seek an adjournment. But if there are none of those situations made, you can get your final order on the first return date. Generally, there'll be a duty lawyer at court. They may or may not assist you going into court, because when a final order is being made, you need to discuss with the magistrate how long you want that order to be for and whether there are any other changes that you would like to be made. Secondly, if the other party is at court, there's an opportunity to negotiate with them. Sometimes you can reach an agreement for an order to be made, but the conditions on the order might need to be varied so that they're acceptable to both. Often having children on an order is a significant issue for the other party. And depending on whether or not you think the children are safe with the other party, you may ask the magistrate to remove the children, or there may be other orders that need to be removed or varied. Now, you may want a lawyer to assist you in the process. There's no expectation that you will directly negotiate with the other party. The courts are set up so that the applicants sit in one area and the affected family members will sit in another family member in another area of the court, and often the duty lawyers will assist you in those negotiations. Duty lawyers are notoriously busy. They'll often have 20 or 30 clients that they need to see, and it can be an extremely long day. So you may want representation to help you through that process, especially if you think there's a good chance of settling it at that point in time. In some cases where the violence is at perhaps a lower level, you may, if you're an applicant, be asked to resolve the matter by the respondent signing an undertaking, which is a promise to the court not to behave in any of the offending behaviours that have triggered this case. Undertakings are not enforceable. They don't have any teeth. Sometimes I say to clients, it's a bit like giving the other party a second chance. And it may be appropriate in your family situation, or it may not. They can be effective in trying to, if you're in a very difficult family situation where there's behaviours that are controlling and coercive, but you're actually thinking, look, I think if we could work on those behaviours, I'd really like the marriage or the relationship to continue. I'm not really ready to separate. You might agree to an undertaking, and you might agree to go to some counselling or family therapy to try and improve the situation for you. So in those scenarios, I think an undertaking has its place, but but there would need to be very low-level violence for it to be appropriate. So I'm just going to talk about the whole court process. If you can't reach an agreement, what will happen is that you will go before the magistrate, and let them know that you can't reach an agreement and that you need the matter to go to a final hearing. The magistrate will extend the interim order, and generally he will bring the matter back for a directions hearing. There are cases where the matter will be brought back for further mention before the directions hearing and before the final hearing. I have been in cases where there have been several mentions, and they're often fairly complex cases, and the magistrate has felt that it needs to come back before her before it goes to a final hearing, because there are other interim matters that need to be sorted out. But in general cases, you will have a directions hearing, which you need to attend. The purpose of the directions hearing is very much a housekeeping exercise. It is another opportunity to try and settle a matter. But it's also to allow the court to set their diary, to find out what the issues are in the case, to find out how many witnesses you intend to call, and how much time is required. So at the directions hearing, the court will tell you when the final hearing is, but you've got to explain to the court how you're going to run the case. There may be orders made for what are known as further and better particulars. The other party is served with your application, where you've written down what evidence you will be relying on for your order. However, you're not really given a great opportunity to expand on all the concerning behaviours and experiences that you've gone through. With further and better particulars, you have an opportunity and are required to set down all the evidence that you will be relying on. Going to a final hearing is not it's not an opportunity to ambush the other side with something that you've never raised before. If you want to raise something at the final hearing, you need to provide details of that evidence in your further and better particulars. And the other side have to know what issue you're going to raise so that they can prepare their case as well. And they can give evidence and respond to those further and better particulars. So you may want to engage a lawyer to help you draft those documents. So eventually, if your case hasn't settled, you will reach a final hearing. Sorry, I forgot to mention that at the directions hearing, there is a facility now where you can ask the magistrate to give you a certificate which will be sent to legal aid, and they will contact you to provide a barrister for the purposes of cross-examination only. You will be required to pay for that service, and you'll have to fill out a means test, and unless you're eligible for that service to be provided for free, you will have to pay a contribution towards it. The barrister that is actually going to represent you at the final hearing will only cross-examine. You may be very lucky and have a barrister that will do a bit more than cross-examine, but that's really all they're provided, that they're being paid to do for you. So at the final hearing, you will have to stand up in the witness box and give the evidence that you're going to rely on, and then if the other side have representation, you can be cross-examined on your question, and that can be very unpleasant and very, very grueling. Typically, if you're cross-examining someone, you'll be looking for inconsistencies in their evidence, and putting things to them just to challenge them in their evidence. And both parties will give evidence and can be cross-examined on that evidence. After all the evidence of the applicant and the respondent and any witnesses has been given, it is then your job to stand up and make submissions on the evidence, addressing the law, and making arguments as to why you should be successful in seeking the orders that you're seeking. And then it's up to the magistrate to decide what's appropriate and what evidence he believes and what evidence he doesn't believe. In many situations, the only evidence you're going to have is your own evidence. There are no witnesses that have seen or witnessed violence. It often happens behind closed doors, and that's very common. And that doesn't mean that your evidence isn't going to be strong or isn't going to be believed. Quite often how you present in the witness box is very persuasive to a magistrate. So after the magistrate has heard all of the evidence, they will make an order that is appropriate. And you can ask the magistrate to make whatever length of order you want. Generally, orders last for 12 months, but not necessarily so, especially where there's been a long history of violence and there's an expectation that you're going to be perhaps unsafe for a long time in the future, because I don't want people coming back to court time and time again. Now, if a final order is made, then if one of the parties is unhappy with that order, you've got 28 days to appeal it. Sorry about that. The appeal will be heard in the county court, and it's really a new hearing of the matter. So it's called a hearing de novo, and you just run your whole case again, basically. If there are family court orders, as I said, they can be suspended, but they will not be suspended permanently. There is an expectation you will go to the family court. Now, if those orders be varied, you can make an application to vary them. A lot of the intervention orders will allow you to attend family dispute resolution or mediation. Often intervention order proceedings are the beginning of a family law dispute, and there are many, many issues that need to be resolved between you. And there may be property that needs to be collected, there may be parenting arrangements that need to be made. And there's facility in the orders for all of that to happen, provided the orders allow it. So you just need to be very mindful that this is perhaps only the beginning of the story, and it is going to continue until all the parenting and property issues have been addressed. So if you need to vary the order, that may be because you want to relax some of the conditions, because you might want to effect a reconciliation, you might want the other party to move back home, or it may be because you want to tighten the orders. The orders may not have allowed the other party they may not have forced the other party out of the home, and you may need an order that has that effect. So you may have thought, look, I need an intervention order. I don't need the other party to be removed out of the home, but I've given them another chance and things haven't improved. I now want them out. So you've got to go back to court and seek that variation. And that can be done at any time during the order. Before the order expires, you might think, look, there's been a few incidents. I still don't feel safe. So before the order expires, you need to go back to court and make an application to extend the order. And that's not going going to be an automatic extension. You've got to fill out documents. They've got to be served on the other side, and there will be a hearing to see whether or not the magistrate thinks you need that order extended. Generally, if there are no breaches of the order, or there have not been any concerning events that have occurred, you may not be successful in that application. They're not going to extend an order just as a matter of course. The other thing you need to be aware of is the effect of the order and what you can do with the intervention order. So an intervention order if you've got an intervention order and there are breaches, no matter how minor they are, your next port of call is to make a complaint to the police. The police are the responsible persons who enforce intervention orders. Intervention orders and the intervention order process is not a criminal process. It's a civil process. However, a breach of an intervention order is criminal, which is why it falls under the jurisdiction of the police to follow up any breaches. Once you've reported breaches to the police treat this like any criminal case. They will investigate. They may take a statement from you, and they will interview all of the relevant parties. And then they have to decide if there is enough evidence to charge the other party with the breach of the intervention order. And the police take breaches very seriously now. We live in a climate where generally the police will prosecute rather than not. So a breach where somebody may have sent you a text message even saying, "Tell the kids I love them," may end up in criminal proceedings. So it's treated very seriously by the police. If the police do prosecute and you're not very happy with that happening, you can issue a statement of no complaint. However, you probably want to get some legal advice about that situation. Secondly, if you don't report breaches to the police, you're actually facilitating the ongoing behaviours by the other party. And if those breaches are fairly dangerous, you can be seen as an accessory to the breach. And so your behaviours can be called into question. And this can be very relevant, especially if there are ongoing family law proceedings. Sending out unclear messages to perpetrators is very dangerous, and that sort of behaviour can be used against you in other courts and jurisdictions. And it's also going to be an issue for the police. They're trying to do their job, and you really need to work in tandem for this whole process to work successfully. Now, if you've been in a situation that is fairly high risk and the police have charged the other, generally that might be for assault or property damage, you can apply for assistance through the Victims of Crime Assistance Tribunal, known as VOCAT. You've got 2 years to bring that application, but the VOCAT Tribunal are fairly generous in extending that period of time if the circumstances warrant it. If there isn't any police involvement, that doesn't mean VOCAT application, but there need to be really good reasons. and those sorts of cases can be fairly complex. And so I suggest you get some advice. Today I can only look at things in a very brief sort of way. Voc can provide interim. They can change locks. There can be interim payments to pay locks and install security cameras. If you make an application for assistance, you can be compensated for your loss of property, medical expenses, loss of earnings. And they can also make awards for other things that may be of assistance to you in recovering from your experiences. And generally these would be for things such as training courses. I've seen quite a lot of cases where holidays have been paid for with you and the family, computers provided, gym memberships. They're quite wide-ranging. And generally, if you've been to a counsellor, the counsellor will write a report, and in that report, recommendations are made as to what will assist you get over the traumas that you've suffered. So the pathway would be to attend a counsellor for a series of sessions. That's paid for. Then she would prepare a report. You'd fill out an application form, and in that application form you detail what sort of assistance you want, and then the magistrate will decide what they consider is appropriate. Other assistance is provided through various domestic violence agencies. And I suggest that you contact your council or police or Google domestic violence services in your area. Some services have been provided with flexible support packages. They were up to $30,000 a couple of years ago, and they can be great sources of support. They've assisted people set up new houses, repurchased damaged goods, purchased white goods, assisted with training. They can be somewhat similar to VOCAT, but I've actually seen them be a little more generous for some people in some situations. If you're in Australia on a spousal visa, intervention orders can assist you in gaining permanent residency, and there are specialist legal services or domestic violence services that can assist you with that. So I guess I just want to finish up by talking about the interrelationship between domestic violence orders and the family court. As I said, intervention orders are often the beginning of a family law dispute, especially a parenting dispute. You've probably all heard about family relationship centres. If you are the applicant with of an intervention order, if you have an order in your favour, my general advice is it's the other party, the respondent, that should initiate mediation at the Family Relationship Centre to arrange to have time with the children. Risk assessments are conducted at those centres, and the other party will receive an invitation to attend. That's not to say applicants that think their children are perhaps missing the other party, or they want to invite the other party to spend time with the children can't initiate. It just depends on the risks and the situation in your family. Maybe contact us, get some legal advice. If you do end up in the family court has got the power to make an order that overrides an intervention order. So the two jurisdictions have to work in together. But as I said earlier, the family court is there to work out what is best for your children. The magistrates court will put boundaries around the family to make sure they're safe. Once, if you are in the position where you're the respondent or have to issue family court proceedings, that's a far more complex and it can be an expensive exercise. The domestic violence story that you've travelled is going to be relevant in that next journey that you might have to take. And the Family Law Act has special provisions that deal with domestic violence and the situation that you're in. The only other thing I think I need to mention is that an intervention order will result in guns being confiscated and the cancellation of a gun licence. And that can impact those who are employed in the security industry or the army. So in that situation, the person who is going to lose their licence can make an application not to become a prohibited person, and that application would be served on the applicant and would have to go before a magistrate. So, there's a lot of flexibility with the orders that are made, how you navigate the system, what level of protection you need and where you need to go, and how big and how small your whole overall story is. So I'm probably going to end it now. I'm sorry for the confusion at the beginning of